This is a brief summary of medical legal aspects of treating patients with mental disorders and learning disabilities. I'm Dr. Prosper Tettey Doe in the United Kingdom. Just an overview of this presentation. We'll be dealing with patients with mental and physical conditions, Informed Consent, Mental Capacity Act 2005, Mental Health Act, and also some definitions on medical treatment for mental disorder, Mental Health Act 1983 interpretation, Section 57, Section 58, Section 62, and Section 63. The law can seem very complicated at times, and as clinicians, we sometimes feel the law is obstructive. Sometimes they are valid complaints, but sometimes, however, the clinician has forgotten that much of the law is based on common sense principles. So treatments of mental health patients for physical conditions, in doing this, we need to know that people with mental disorders or learning disabilities who require treatment for a physical condition that is not a symptoms or causative of a mental disorder must be approached in exactly the same way as people who have a physical illness but do not have a mental disorder or learning disability. Now, in treating the patients with mental disorders for physical conditions related to their mental disorder, if a patient who is detained requires treatment for a physical condition which is connected to his or her mental disorder, then he may be treated under the provisions of the Mental Health Act. The treatment must fall within the definition of medical treatment for a mental disorder. Now, we have rules for management of people with mental disorders who require treatment for physical illness unrelated to that mental disorder. And that's relatively straightforward. If a person with a mental disorder requires treatment that does not fall within the definition of treatment for mental disorder within the meaning of the Mental Health Act 1983, then he or she must be treated as follows in accordance with the common law principles of informed consent or under the Mental Capacity Act 2005. And the overview, I'll go into that detail. Under this, there are two categories. One is the physical illness is related to their mental disorder, or two, the physical illness is not related to their mental disorder. This can further be subdivided as follows: treating people who have capacity to make a treatment choice and treating people who lack capacity to make a treatment choice. So, to recap, for a patient with mental disorder requiring treatment for physical conditions, there's two channels. The first channel is it related to mental disorder? Or the second, not related to mental disorder. If it's the first, related to mental disorder, then Mental Health Act. If it's the second, which is not related to mental disorder, there's a Mental Capacity Act. And one may ask if that is applicable. The Mental Capacity Act, if it's yes, patient has autonomy and can make any decision they like as long as it is voluntary and they are properly informed. Or if no, they don't have mental capacity, do they have a valid advance decision? If they have a valid advance decision, respect that decision. If they don't have a valid advance decision, then consider these three options. Is the situation urgent? If it's urgent, then the doctrine of emergency needs to be applied. If the incapacity is long-term, then the best interest principle applies. And thirdly, if the patient is likely to regain capacity soon, then the principle of interim measures need to be applied. Now, some definitions. Medical treatment of a mental disorder. Medical treatment for a mental disorder means treatment which is for the purpose of alleviating or preventing a worsening of a mental disorder or one or more of its symptoms or manifestations, as in the Code of Practice, Mental Health Act 1983, Section 145, subsection 4, as revised in 2008. The Mental Health Act 1983 provides for the compulsory detention of mentally disordered patients. It also includes a framework in Part 4 for the treatment of non-consenting patients. Now, Section 57. Briefly, patients must be capable of giving and give their consent to these interventions, and the treating clinicians must first consult with two other professionals, one of which shall be neither a nurse nor a doctor, and neither of which shall be the patient's responsible clinician, before proceeding with treatment. Under Section 58, this applies to medication and sets out the certification and consultation requirements when treating a patient for longer than 3 months, and only applies to detained patients. So in summary, unless the treatment is urgent and covered by Section 62, the patient should not be treated unless he is capable of giving and has given his consent, or if he is not capable of giving consent, an independent doctor has certified if the treatment is being given after 3 months, that's fact, and that the treatment is appropriate. Now, Section 62 provides that the rules set out in Section 57 and 58 do not apply in urgent situations. Where the situation is urgent, treatment, which is 1, immediately necessary to save a patient's life, 2, intended to alleviate suffering or to prevent a serious deterioration, and 3, not irreversible or hazardous, may be given as long as it is proportionate intervention to prevent a patient from behaving violently or being a danger to himself or others, subject to certain qualifications. Electroconvulsive therapy, ECT, may be given under this section. ECT is otherwise covered under section 58A. Treatment of patient with community treatment order is covered in another different section. Section 63 provides that treatment that does not fall within the remit of section 57, 58, and section 58A can't be given without consent as long as it is medical treatment for a mental disorder. Now, interpretation of the Mental Health Act 1983. Section 145, paragraph 1. In this act, unless the context otherwise requires, medical treatment includes nursing, psychological intervention, and specialist mental health habilitation, rehabilitation, and care. But also see the subsection 4, which is any reference in this act to medical treatment in relation to mental disorder shall be construed as a reference to the medical treatment, the purpose of which is to alleviate or prevent a worsening of the disorder or one or more of its symptoms or manifestation. Now, what constitutes medical treatment for mental disorder? Now, there's a leading case on this subject. That's B versus Croydon in 1995. In summary, where a refusal to eat is a symptom of the patient's disorder, feeding will fall within the definition of treatment for mental disorder. Further forms of physical intervention, which may fall within the definition of medical treatment for mental disorder, include the monitoring of the blood pressure of a patient on clozapine, because the monitoring is an essential adjunct to the main treatment. Also, assisting a patient to bath, where the patient's refusal to address personal hygiene is deemed to be a symptom of the mental disorder. Also, treating a patient with thyroxine where a psychosis has developed as a result of hypothyroidism. Also, feeding a patient with anorexia nervosa via a nasogastric tube. Also, treatment with intravenous fluids where a patient stops eating and drinking due to severe depression, which in turn leads to severe dehydration. So these are important points. And the next point is treating those with mental disorders for physical conditions not related to their mental disorder. Mental capacity assessments. Mental Capacity Act 2005 codified the tests for capacity that must be used. The capacity test has its origins in the case law. Capacity assessment must be done if there is a possibility that the patient's decision-making ability might be compromised in some way, and patients have the right to make decisions that other people think are unwise. An irrational decision is only evidence of one aspect of incapacity. A doctor must measure a patient's ability to weigh up or process the information specific to the treatment in question. People have different beliefs and principles. Some might think the patient's decision to choose death over amputation, as in the case of C, was illogical. However, the court decided that the patient was capable of processing the information about the various treatment options and applying it to his own life and principle. And one can compare him, however, with a self-harming patient who refuses a blood transfusion despite having dangerously low hemoglobin level. The reason she gives for refusing is that she believes that blood is evil and makes her do evil things, and that the less blood she has in her body, the less likely she is to do evil things. It will probably be reasonable to conclude that this was an irrational decision in the extraordinary sense, and thus the doctor might conclude the individual lacks capacity. The doctor might also want to consider whether the irrational decision is linked to or is a result of the patient's mental disorder. Example, a refusal to eat might be manipulative behavior symptomatic of personality disorder, or it could be a political protest. There's two-stage capacity test. A patient is deemed to lack mental capacity if he is unable to make the decision in question because of impairment or disturbance in the functioning of his mind or brain. In particular, the statute states that a person lacks capacity in relation to a matter if at the material time he, one, is unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. It does not matter whether the impairment or disturbance is permanent or temporary. That's the Mental Capacity Act 2005, Section 2. And 2, is unable to make a decision for himself because he cannot, 1, understand the relevant information, and or 2, retain that information, and or 3, use or weigh that information to reach a decision, and or 4, communicate his decision through speech, sign language, or any other means. That's the Mental Capacity Act 2005, Section 3. A person should not be regarded as unable to understand relevant information if he is able to understand an explanation given in a way appropriate to his circumstances, such as simple language, visual aids, or any other means. A person is not to be regarded as unable to retain information if he's able to retain the relevant information for a short period only. Information relevant to a decision include, but is not limited to, information about the reasonably foreseeable consequences of deciding one way or another, or failing to make the decision. Capacity is decision specific. A higher level of capacity is required for more serious decisions. You should always have a view as to whether your patient has capacity or not. If it is not clear whether the patient has mental capacity for the decision being made, then a second opinion should be sought. If both clinicians are uncertain, then an independent psychiatrist and/or a lawyer should be contacted. The expression "sitting on the fence" is used for those who are undecided, and the fence is not a good place to be when it comes to capacity assessment. Now, the standard of proof when assessing capacity is the balance of probabilities. So when assessing capacity, doctors should ask, is it more likely than not that this person has or does not have capacity? And the responsibility for capacity assessment, the person responsible for the capacity assessment is the person who is going to be carrying out the proposed treatment, examination, or test. If a psychiatrist is asked for an opinion by, for example, a surgeon, the psychiatrist does not assume overall responsibility for the assessment of the patient's capacity to consent to surgery. The psychiatrist acts in an advisory capacity only. And documentation of capacity assessment is very important. And treating patients with capacity, if a doctor treats a patient who has capacity against the individual's wishes or without first obtaining proper informed consent, he can be disciplined by his employer, sued through the civil courts, and can be erased from the medical register. Patients with capacity have autonomy and can make any decisions they wish, even if the decision results in their death, as long as the decision is voluntary and the individual is properly informed about the proposed treatment and its risks and benefits and any alternative treatment. Healthcare professionals must therefore make sure that patients are not coerced in any way, as duress can vitiate consent. This includes coercion from healthcare professionals, family, friends, and carers, as well as other service users. The duty to inform patients must not be underestimated. Patients are entitled to and must receive information about the risk of, benefits of, alternatives to, and together with the risks and benefits of each alternative. Also, material information about the proposed treatment is necessary, and the patient is able to take time off work without making prior arrangements. Their job involved driving, and weight is a significant concern. In material information being given is important in these respects. And the patient's condition should be noted, especially regarding their unique personality and circumstances, such as their job, home circumstance, and personality, which may require establishing whether the patient is able to take time off work without making without prior arrangements, whether their job involves driving, and weight is a significant concern. So the next is treating patients who lack capacity. urgent treatment, the doctrine of emergency. Patients may be treated in emergency situations when it is not possible for them to give consent, perhaps because they are unconscious or in considerable pain. The legal principle is that patients may be treated provided that it is a defined emergency. The treatment is to prevent a serious deterioration in the patient's physical or natural condition, and no treatment is given beyond the point of crisis. And that is important. There's a case study of an emergency treatment of a psychiatric patient. A community patient who had consumed a quantity of alcohol and painkillers falls down a railway embankment, sustaining multiple injuries. She is brought to the accident and emergency department but refuses treatment. A clinician may not force treatment of any sort on a patient who has capacity unless that treatment falls within the scope of the Mental Health Act 1983. Or if the doctor suspects that the patient's decision-making ability might be compromised, they must do a capacity assessment and decide, one, if on balance of probabilities, the patient has an impairment or disturbance in the mind or brain. Two, if that impairment has affected the patient's ability to retain or understand the information, or her ability to use or weigh that information to make a decision on whether to accept life-saving treatment. If so, then emergency treatment to prevent a serious deterioration in physical health or mental well-being, but not treatment past the point of crisis, could and should be carried out. Now, restraints. Health professionals are entitled to use restraints to treat under the doctrine of emergency and the doctrine of best interest. Restraint is defined in the Mental Capacity Act 2005 as the use of force or the threat of force to make someone do something they are resisting, or restricting someone's freedom of movement, whether they are resisting or not. Restraint is appropriate and does not require special authorization if it is used to prevent harm to someone who lacks capacity or falls short of a deprivation of liberty, and is a proportionate response to the likelihood and seriousness of harm. Now, deprivation of liberty. Where the use of restraint can be said to amount to a deprivation of liberty, healthcare professionals must apply for authorization to undertake the acts that constitute the deprivation. This deprivation of liberty safeguards laws are enshrined in the amended Mental Capacity Act 2005 and were prompted by the case of Bournemouth. That's the Bournemouth case, Bournemouth case. A man with autism lacked capacity to decide whether or not he should be admitted to hospital. His carers wanted to remove him from hospital, but their request was refused by the hospital, who continued to treat him on an informal basis that is not under the Mental Health Act 1983. which meant that there was no right of appeal or right to a second opinion. The European Court considered the case and had to decide two things: whether there had been a deprivation of liberty or just an appropriate use of restraint. Also, if there had been a deprivation of liberty, whether the deprivation of liberty had taken place in accordance with a procedure prescribed by law. The court held that there had been a deprivation of liberty and that there was no procedure prescribed by law. The government in England responded to the ruling by introducing deprivation of liberty safeguards, a procedure prescribed by law for depriving patients who lack capacity and are not detained of their liberty. Now, advanced decisions. Advanced decision is a decision made by a capacitous adult which states that if in the future, at a time when the person lacks capacity and in specified circumstances, certain treatment is proposed, the treatment is not to be carried out or continued. An advanced decision is therefore an advanced refusal, such as a refusal to have a blood transfusion on religious grounds. Advanced decisions do not need to be witnessed and signed by the patient in order to be valid unless they relate to life-sustaining treatment. For this is important to look at the Section 24 onwards of the Mental Capacity Act 2005. If the validity of an advanced decision is unclear, seek legal advice. The next is court of protection. The Court of Protection, created by the Mental Capacity Act 2005, has a comprehensive jurisdiction over the health and welfare and financial affairs of people who lack capacity. Court of Protection may make orders such as declaration as to mental capacity, declarations as to best interests, single orders, appointment of a deputy, declarations as to validity of lasting powers of attorney, orders related to financial matters, single orders, declarations as to the lawfulness or otherwise of any act done or yet to be done in relation to a patient, declaration as to the existence, validity, and applicability of advanced decisions. Now, the next is lasting powers of attorney. The Mental Capacity Act 2005 created a new lasting power of attorney, which can be used to assign to another person the right to make decisions on a patient's behalf relating to health, welfare, property, money. The attorney must always act in the best interest of the donee, that is the patient. The format of a lasting power of attorney is set out in Schedule 1, Part 1 of the Mental Capacity Act 2005. The forms and guidance can be found in the Office of the Public Guardian. Now, single orders or deputies. If a doctor is faced with family members who all have different and strong views, he could consider obtaining a single order from the Court of Protection to resolve the dispute. If a patient has not appointed someone to make healthcare decisions on their behalf by way of a lasting power of attorney, the Court of Protection may appoint a deputy who is likely to have some relationship to the patient. However, the deputy's appointment is likely to be very limited in scope and duration. Deputies are likely to be appointed in rare cases, for example, where there is a dispute between family members as to who has the patient's best interests at heart, and where the patient has chronic and or degenerative health problems, calling for repeated assessments and decisions by doctors and carers. Government's response to recommendation 54 of the Joint Committee's report, which can be referred to, that's www.parliament.the-statutory-office.com. If there's a lasting power of attorney, any disputes must be resolved by way of single order of the courts, rather than by the appointment of a deputy. Now, they are independent advocates. The Mental Capacity Act 2005 sets up a service called the Independent Mental Capacity Advocate, IMCA, to help those with no family or friends. Doctors have a duty to contact an IMCA if there's no one they can involve in a best interest assessment. Then there's the public guardian, is in charge of the office of the public guardian that will help the court of protection by looking after the applications and paperwork for lasting powers of attorney and deputies. Additionally, they monitor the work of the deputies and work with the police and social services if it is suspected a vulnerable person is being abused. The Caldecott principles. These are: justify the purposes of using confidential information, only use it when absolutely necessary, use the minimum that is required, access should be on a strict need-to-know basis. Everyone must understand his or her responsibilities and understand and comply with the law. Information sharing. The principle of information or informed consent apply to information sharing. So if a patient has capacity, the doctor should seek consent to share information. There's a Data Protection Act 1998 that needs to also to be looked at. So all these are important. So in summary, a person with mental disorder or learning disability who requires treatment for a physical condition that is not a symptom or causative of a mental disorder must be approached in exactly the same way as a person who has a physical illness but does not have a mental disorder or learning disability. The next point is, if a person with a mental disorder requires treatment that does not fall within the definitions of treatment for mental disorder within the meaning of the Mental Health Act 1983, then he or she must be treated in accordance with the common law principles of informed consent or under the Mental Capacity Act 2005 if the patient is over 16 and lacks mental capacity. Next, if a patient who is detainable requires treatment for a physical condition which is connected to a mental disorder, then the patient may be treated under the provisions of the Mental Health Act 1983. Also, a detainable patient cannot be forced to have any treatment that is unrelated to a mental disorder unless the patient lacks mental capacity, in which case treatment may be possible under the Mental Capacity Act 2005, not the Mental Health Act 1983. Also, patients have the right to make decisions that other people think are unwise. An irrational decision is only evidence of one aspect of incapacity. Also, the standard of proof for mental capacity is the balance of probabilities. And the person responsible for the capacity assessment is the person who is going to be carrying out the post-treatment examination or test. Carefully document the rationale used to reach the decisions made about a person's mental capacity, as well as the actions taken. If a doctor treats a patient who has mental capacity against the individual's wishes or without first obtaining proper informed consent, the doctor can be disciplined by their employer, sued through the civil courts, and erased from the medical register. And finally, it's strongly recommended that the doctor joins a medical defense organization, whether or not the employer provides indemnity, as these organizations protect the doctor's interests, which may differ from the interests of their employers.